The purpose behind cross-examination is to bring out points favorable to your case. Apparently, that was lost on Mr. Victor in this case. Hey there, Tony DeWitt here. I'm a retired Missouri attorney now living my best life on a beach in Florida. But I do not dispense legal advice by video. With that understanding out of the way, here's what we're discussing today. So we're back today in the Natalie Cochran case. So by now, we already know that we have a verdict in this case, and I don't think it's any surprise. One of the defense attorneys said he was shocked by the result. No, he wasn't really. I mean, let's face it. He knew what happened here. And this is just a short follow-up on the last day of the trial. They had some rebuttal testimony from the state. They brought in the state trooper, and he ran through a number of texts, and I think he did a pretty good job of trying to rebut some of the points raised by the defense. But then, of course, the defense got a chance to cross-examine him. And one of the things that I keep saying a lot, I think, is that cross-examination should be surgical. It should be done on things where you know you can win points. And when you've won all the points you can win, you don't ask questions you don't know the answer to. And perhaps the worst thing you can do when you cross-examine someone, particularly when their answers are inherently reasonable, is mock those answers. Let's start with how the defense began this cross-examination.
Mr. Heinzman, the purpose of your testimony here today is to demonstrate that Michael Cochran, and this is an old story, was duped by my client, Natalie Cochran, and didn't know anything about these contracts, right?
Yes.
And for that matter, the other message there that you are telling the jury about is that Natalie Cochran was involved in the illicit business of contracts. Is that right?
Yes, that's correct.
Would you agree with me, sir, that throughout this trial, as you were sitting here, we have conceded that Natalie Cochran was a bad girl and she was dealing in those federal contracts? Did we concede it or not?
Did you concede to it? I don't know who we is.
Listen carefully. Is it true that Natalie Cochran has conceded that she was involved in the fraudulent scheme?
Yes, she did.
So that shouldn't be any surprise for you when you look at all these documents. That she is involved in these transactions.
The purpose of my testimony was to illustrate that Michael Cochran was not involved in the illicit transactions.
Michael Cochran wasn't involved in it. All right. I'm going to ask you, looking at one of the examples. Yes. I do not recall which number it was. I think it's somewhere around 5 or 6. But you testified about this document, didn't you?
Yes, I did.
That document was telling you that on August the 30th, and I presume 2018, $1.2 million was going to be posted, right? See it there?
On August 30th, yes.
Yeah. Posted in the account of Mr. and Mrs. Cochran, right?
Yes.
Then on September the 4th, I'm sorry, the 3rd, $724,000 was going to be posted. May not be the 3rd because it's gonna be a holiday, but it was gonna be posted in the Cochran's account, right?
Yes.
And then $2.56 million next Friday was gonna be posted in their account, right?
Yes.
Well, comes August 28th, no money in the account, right?
Correct.
Comes August 29th, no money in the account.
Correct.
Comes the end of September, no money in the account, right? Right?
Yes.
Yes. Well, that $2.6 million next Friday, so that's probably sometime, I don't know, sometime at the beginning of September, right? No $2.6 million coming.
Correct.
And Mr. Cochran doesn't know that? He is waiting for about $4 million, right? Right?
The last date put out on these is December, so between August 27th and December, it was over $300 million that he was
I
told
asked
was
you
due.
about these numbers. 300,000, $1.2 million, $724,000, $2.6 million. There's nothing about December there, is there?
December 21st on the next one down. 12/21, $131 million on 12/21.
I didn't ask you about that, sir.
You're-
I asked you about the top, the
Okay,
exhibit. There's about $4 million coming to Michael Cochran, to his account, right?
to the business. Yes,
To the business where Michael Cochran is a minority owner, right?
no,
No? To the business where he has a joint account, right? Yes, sir? Yes or no?
yes,
Yes. $4 million coming to my account, and I don't know anything about it?
that is correct.
Now, that potentially could have been pretty impressive. It could have been a really good cross-examination if he had followed up on it and if he had nailed down the issues. But he's got a problem. He's going up against a trained investigator who has been cross-examined repeatedly and who knows how to answer a question. And as you saw, the officer there, the trooper, was giving information that he had in front of him that he knew was accurate. But the answer to the question of Michael did or did not know, he gave completely. He completely undercut everything he had achieved with all of that when he asked that final question. Michael didn't know? Yes, that's exactly what my testimony is. He did not know. And so, what's the effect of that? That buttresses the case even more for the prosecution. It was a very ineffective part of a cross-examination.
Not that depiction. Well, they don't talk about any of the wealth that the Cochrans, plural, have acquired through the illegal schemes and enjoyed for a long time, right?
These documents do not.
These documents don't deal with anything about Michael Cochran's health. Honey, I feel bad today, I'm declining, or anything of that nature.
There are references to him being stressed because of the lack of money.
He is stressed because he doesn't know.
In these documents I'm referring to.
He's like in a National Enquirer. We want to know, right? He wants to know, right?
He wants to know where the money is that they've earned.
wants to know.
Through what he believed was legitimately awarded government contracts.
Right. And yet he goes to a boat sale and buys himself 2 boats at the same time, right?
I don't know if he went to a boat sale. I know that he did purchase ATVs, boats, vehicles,
Right.
things of that nature that both he and his wife picked out based on text messages we read, or by her encouragement to make purchases because she had led him to believe that they had all
Sure,
this
she let him
wealth.
to believe.
I don't think he understands the purpose of cross examination here. He just elicited testimony and agreed with the testimony that he didn't know. I'm not sure he really understands what he's doing up there because he's not helping Natalie's case at all. Again, I have to wonder whether he's setting up ineffective assistance of counsel. And I just have to say that every time I hear this guy ask a question, in the back of my mind, this is what's playing.
Think, darling, think. There must be something really rotten we can do today.
I'm thinking.
Now, again, that line of questioning could have been effective if it had been done right. For example, Mr. Cochran was expecting this money, right? And you get an immediate right. But it didn't come in, right? Right. And then a couple of days later, he's expecting this money and it didn't come in, right? Right. And then he was expecting this money and it didn't come in, right? Right. Now, at what point was it reasonable for him to start suspecting that there was something wrong here? Well, that calls for speculation, so that would probably be objected to and ruled inadmissible, which is okay because it's not the answer that's important, it's the question that's important. And if the prosecution successfully avoids him answering that question, it makes the jury think, that must have really hurt them or something. So it could have been done effectively, but it wasn't done effectively. And part of it is just his inability to communicate in a way that doesn't force you to listen for every syllable so you can figure out what the heck he's saying.
Well, is it possible that since they have no income, independent income, you testified that Natalie wasn't working as a pharmacist anymore, and Michael's job was an IT man, not really defined, that he's pulling $9,500 in cash that must have come from the investors, right?
Yes.
So he pulls $9,500 that he considers money earned, right?
From previous contracts.
If
Yes.
if he believes that, if he's so scrupulously honest, well, he must believe that this is the money that they've already earned on those contracts, right?
Right. He's not aware that there are illicit proceeds. He thinks they're legitimate proceeds.
Right.
Right.
What does $9,500 tell you as an investigator of money laundering?
Well, that
Cash. I'm gonna ask 9,500 cash. What does that tell you? You're the expert here on money laundering.
Sure. In this context, it means nothing. In the context that you're framing it, it references currency transaction reports. Those are a federal requirement under the Bank Secrecy Act.
Well, let me ask you
Where-
this. Let me ask you this. Every,
Yes.
well, I'll ask a very specific question. Under
The witness should be permitted to answer. Go
explain
ahead,
that
Mr.
$10,000
Ansel.
cash.
The Bank Secrecy Act requires financial institutions to file what's called a currency transaction report for any transaction involving $10,000 of U.S. currency, that'd be cash or coin, in or out of a financial institution. It is a derivative of the Patriot Act and the War on Terrorism, so they want to track large amounts of cash. So if a withdrawal from a financial institution were to occur above $10,000, the bank would be required to complete a currency transaction report and document that transaction. In this case, however,
Well, I'm
the
sorry.
Cochrans
Now
had
let me.
cash
I'm
inside
sorry.
a
I'm
safe.
sorry, Your Honor.
Okay,
Now the question is this:
fair enough. He's answered the question. Go ahead, Mr. Victor.
$9,500 in cash is obviously under 10 grand, right?
It is.
And he withdraws that amount of money in cash, right?
Yes.
Would you agree with me that he does that for the purpose to avoid the $10,000 money reporting necessity?
No, I would not.
No?
That's not illegal. It's not an illegal act. It's when that is anything 10,000 or more is
Right.
taken out in multiple increments over a short period of time, that would then trigger what's called a suspicious activity report
Right.
with the bank that ties back into the currency transaction report.
And
So
that's why-
that amount alone is not illegal.
And that's why he's taking $9,500 rather than 10,000, because he would have to report it to the IRS.
Your Honor, that's speculation. There's no way the
Wow.
witness could read the
Sustained.
defendant.
All right.
I don't know what he thought he was doing there. He sets up this idea that, he was going to take this $9,500 out. But the detective there, or the trooper, says, no, he thought this was, earned profits. And again, our defense attorney agrees with him and then goes into this money laundering issue, which, as near as I can tell, has no nexus whatsoever to anything going on in the case. But he essentially makes the claim that he's taken out $9,500 because he doesn't want to take out $10,000. But again, as it is very clear on the objection there, that calls for speculation. And again, he doesn't land the blow that he thought he was going to land. I'm not even sure that part of the entire cross-examination was really necessary. This is really a sad case. I think there is a defense that could have been put on for Natalie that might have resulted in maybe getting one juror, maybe getting a hung jury. That would have been at least a little bit of a victory for her. I think this could have been done better. I think it should have been done better. That it wasn't done better might very well open up the possibility of there being some kind of ineffective assistance claim. The fact that Natalie wasn't allowed to testify, I don't think that's going to come in at all. I think that was probably the smartest decision that they made in this case. But this has not been handled well, and I feel in some ways sorry for Natalie that she didn't get a better defense out of these two attorneys who are representing her. I'm not calling them bad attorneys. I'm just saying they didn't do the best job that could have been done, particularly with regard to cross-examining some of these witnesses. And they would have done a better job if they'd had some kind of medical background or at least sought out the answers to some of these medical questions before they started down this road. So that's what I have for you today. Thank you for watching. Thanks for watching my video. If you have a request for me to cover a topic, please send me an email to the address above, and in the subject line put video request. If you have comments, drop them in the comments down below. If you found the content worthy, please consider subscribing. Since I started doing this work, I have always asked listeners to consider doing just one kind thing every day to make somebody else smile or make their life better in some way. Please consider doing that. It makes the world a better place. Now, YouTube has some suggestions for other videos of mine you may find interesting.